Most law students don't go to law school expecting to learn math. But torts students soon encounter a notable exception. In United States v. Carroll Towing Company, Judge Learned Hand devised a mathematical formula for assessing responsibility in negligence cases. In January 1944, on the North River off Manhattan Island, a barge named the Anna C. was tied to the end of Pier 52. From there, 5 other barges were tied off to the Anna C. At the end of the next pier upstream, called the Public Pier, 4 more barges were also tied off. A line connected the outermost barge moored at the Public Pier to the 4th barge in the tier of barges tied off to Pier 52. The Connors Marine Company owned the Anna C., which carried a cargo of flour belonging to the United States government. The tugboat Carroll, owned by the Carroll Towing Company, was assigned to remove one of the barges tied off to the Public Pier. To get to the barge, it had to untie the line between the 2 tiers of barges. The Carroll's captain nosed her up to the outside barge on Pier 52 and sent a crew to untie the line. The crew did so and then climbed back onto the tugboat. They were barely back aboard the Carroll when the entire tier of barges broke free from Pier 52 and began drifting downstream. The Anna C. hit a freighter docked at Pier 51, breaking a hole in the barge's hull. The Anna C. filled with water, dumped her cargo, and sank. The Connors Company had assigned a bargeman to the Anna C., but he was nowhere to be found during the incident. The United States sued Carroll Towing for its lost flour. Connors, the owner of the Anna C., also sued Carroll for damages to their barge. Focusing on the damage to the Anna C., Carroll responded that Connors wasn't entitled to damages because its own bargeman was absent. Without a bargeman aboard, Carroll argued that Connors hadn't taken care of its own barge, exacerbating the damage to the barge and her cargo. The federal district court ruled that Carroll owed Connors 1/2 the damages to the Anna C. Carroll appealed to the Second Circuit Court of Appeals.